Good job yesterday. It's nice, loud, clear. Great.
Thank you, Your Honor.
Yeah. Mr. Aguilar, you're charged with failure to stop and give information, striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take it, Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DIMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
And he was the seller on Facebook Marketplace. There's no information in the DIMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right? It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DIMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give information.
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't.
Oh, no,
You
no,
have the
sir.
right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you.
Yes, sir.
Just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Tell Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay. I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. Do you understand me?
I understand.
Come on.
All right, Judge, next is page 15. Issa?
Can you file those bond conditions, please? No contact with the plain witness, no going within 200 feet of where they live, where they work, must maintain car insurance, no new cases. Good morning, Mr. Hissa. So you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On March 26, 2025, in Harris County, Texas, an officer was dispatched to a vehicle accident. The complaining witness stated he was driving when he noticed the defendant was tailgating him in his truck. The complaining witness stated he brake checked the truck. The complaining witness stated he attempted to change lanes to let the defendant through. The complaining witness stated the truck went around him, got on the median, and then collided with the complaining witness's vehicle on the side. The complaining witness stated the defendant pulled ahead of him and turned to leave the scene. The complaining witness stated he followed the defendant and got in front of his truck to prevent him from leaving. The complaining witness and the defendant exited their vehicles. The complaining witness stated the defendant came up to his face and was yelling that the defendant was trying to find a good place to stop. The complaining witness stated the defendant got in his motor vehicle and left without providing his driver's license or insurance. The complaining witness stated he did not want to press charges. The complaining witness estimated damages to be $500. An officer ran the plate provided by the complaining witness. There was a driver's license attached to the plate. The officers ran the attached driver's license and got a return photo, and the complaining witness ID'd the defendant by this driver's license photo that the officer showed him.
Mr. Hissa, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running his license, please?
Sure.
City has a valid license. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If I find that you drive without either, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer?
I think so. Yes,
Okay,
yes.
we'll give you time. If you have any problems, just come back and talk, and then we can go further. If you need an appointed lawyer or anything, we can always have you fill out an application. So for now, I will have you go to Victoria, sign a reset. We will then have you take a seat in the jury box while I get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go. All right? Please. Do you mind filing those conditions, please?
Yes, sir.
And then I'd like to know if he still has a license or not.
Absolutely. And, could you restate those conditions for me?
No driving without a valid license and insurance.
Yes, sir.
Your Honor, his license is eligible.
Great. Okay.
Yes, Your Honor.
All right, Judge, next is page 20. McQueen, come on up.
You're Mr. McQueen? It's not an answer.
Yes, sir.
Mr. McQueen, you're charged with indecent assault by contact with fluid. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yeah.
Your Honor.
Your Honor, if I may, I believe we already read probable
Yeah.
cause and you found probable cause on this case. But
That's what I was about to say.
Is this an arraignment?
It was last Tuesday.
Oh, yes, Judge, you set a bond, 415. Oh, that's right. We did bond conditions and then let him go with the bonding company to post a bond. So this is his arrangement.
Ah, got it. Okay, so what we'll do is, do you have a lawyer?
Yeah. But her mother just died, so she's not here today. So she said she's been trying to call whoever answers the phone to tell them.
To set him CHA, because this is his.
Yeah, that's okay. Yeah, all right. So we're gonna give you more time regardless, since she's not here or he. We'll just have you sign a reset and then we'll have you get going. All right? Okay, please.
Judge, we have two other arraignments with attorneys, but they're just not here yet.
Okay, I guess we'll just wait.
Okay.
Ray, hi,
Hi,
ready?
sure.
We're still going, right?
That's right, I'm, yeah.
Okay,
I thought
any,
it raised, kind of like I said yesterday, we really got into the blue, so.
yeah, okay. Anything that you want to take up prior to any kind of motions and
We were
limiting?
just discussing the complaint, not addressing the prior. It's not charged as a second issue. It's put on there as a enhancement paragraph.
It's not a jurisdictional.
So from what I can see, it doesn't look jurisdictional. Yeah.
It's is it Martin?
Thomas.
Yeah.
Basically, that wouldn't be in our case in chief, it'd be on punishment.
There you go, you're pretty good.
Because they've also got the 0.15 alleged on there. That is in their case, that has to be in their case in chief.
Right. But the
So
second is
just,
not.
just the 0.15 itself makes it a class A in and of itself, right?
Right. And normally we wouldn't,
I mean, I see that there is the,
right, but it's not a jurisdictional enhancement, Your Honor. It would just be a punishment. So it wouldn't be in our case in chief, it would just be in our punishment case.
sure,
Right,
of course.
but it's not, that's what we were just trying to figure out.
Right, because the 0.15
It mentioned.
during case in chief, right,
Correct. Correct. The only
Yeah.
time you do that is on DWA thirds, because that is jurisdictional.
right, because that's jurisdictional.
Yeah,
Then
you're
you
right.
have to make it a felony.
Cool.
Yeah, so I think that's really, and I'd also
Also,
like,
don't mention the 15, you know, right?
Well, I think that would.
And when you're arraigning,
No, oh yeah, when in arraignment, no, obviously, I was, during the case in chief that we would have evidence, obviously, but yes,
Sure.
during arraignment, no.
okay,
and then I would also like for the state not to mention anything to have to do with his immigration issues or ICE hold or anything to that
We are
effect.
completely in agreement on that.
Thank you.
We had some,
nice and clean. Hi,
Hi, Judge.
good to see you. What's new? Do you have something?
A
Do
case on the docket today, Figueroa.
We have some other motions that I think, but
you want to talk about it first and then let me know if
Um,
you disagree?
we'll talk to Ray. I mean, I don't think, we'll talk to Ray first and see what he's.
If you disagree on anything, just let me know.
Okay.
Okay, Figueroa?
Yes.
Great to see you.
Great to see you. It's a GWI. We had an accident, and so we were applying for PTI. We had to do a mitigation packet, which I just submitted yesterday. So
So,
we're at 180 days, so she told me I need to approach.
T-Raz, it's completed. Okay, so we'll give you 2.5 weeks.
I submitted the packet yesterday already.
Yeah,
I'm just waiting to hear. It's gonna obviously just take time.
okay.
Yeah.
Yeah, we'll give you time.
Thank you.
Sure. Good to see you.
Thank you. Good to see you too. Oh, did we want the result form? Okay, that'd be great. Then I can forward them to the DA's office.
Good morning. I've got two things to talk to you about. Since Chief is here, we'll start with that one. You may remember on Thursday, we were going to address a BVR on Sierra Torrance,
Okay.
and then we were going to do the bond hearing today.
Okay.
The state was able to get the witness here. About the scram. Unfortunately, Miss Sierra will not be here today. She's getting picked up on some Class C warrants. So she's going into custody. So I guess the problem has solved itself as far as the BVR.
She wasn't required to be here anyways.
Well, she has to be here for the,
I know, but we didn't require her presence today.
okay.
How can I revoke her bond if she was required?
Well, that was going to be my next argument.
But if she's not here, I mean, can you have them come Thursday? So you were gonna have a witness come, right?
Yes, and he's here. He's present.
Can you come Thursday?
Yes,
You mind?
I don't mind.
You can also zoom in as well. Are you, I mean, do you have an objection with that?
Yes.
Okay, yeah, we need you here Thursday. If she's not here Thursday, that's the day we're set. I'm not gonna revoke the bond if I didn't require her presence here today and I didn't.
Okay.
Right?
Okay. But yes,
Yeah.
well,
I'm not, that's not fair.
okay. Well, that was gonna be my next argument, Judge, but she's just not gonna be here. I know y'all are about to pick a jury. I'm about to pick a jury, so.
Regardless, I didn't.
Do it on Monday, please.
This is for.
Yeah, on Torrance.
Can we do it on Monday
It's Monday.
Yeah,
No.
hang on, they're
or,
gonna,
or Wednesday? I can't be
No,
here.
because we have a
I a
witness
doctor's
coming
appointment.
in. She's supposed to be here. It's been over and over. I mean, I can ask for another report if you can't be here, you know?
Okay,
okay, so Thursday.
This Thursday.
Okay. And then I have another one to talk to you about that's easy, that's on today's docket, and it's Zepeda. It's 140-ish days old. We are still waiting on surveillance video. I've spoken with the state. They've escalated their request, but Victoria told me I needed to talk to you.
It's only 140 though. I mean, maybe just because you haven't gotten videos.
Yeah.
I
just-
What's the word?
Judge, I do whatever she tells me to.
I believe we put an escalation order for the surveillance video. Guys, when was the escalation for Zepeda in town?
I mean, let me put it to you, this, I'm not gonna wait forever. Justice delayed, justice denied. So, you know, I'll give you one more setting, right?
Thank you, Judge.
Okay. Thank you. Maybe excused. Okay, did it.
I know you will.
Okay, thank you.
Right.
So for our PowerPoints, I noticed that the defense connection is straight coming up here to your connector.
I'm not getting anything. What?
Yeah, it's running. One's right here. This is connected to the defense side. It's coming right up there. So do you want us to put our PowerPoints through Zoom?
No.
Like share?
PowerPoints go through
Okay,
the,
then we probably need IT up here because I don't want to disconnect something that we shouldn't disconnect. Because I was trying to check it and then I came over here and saw that it's running all the way up here. I'm like, okay.
So, hey, morning, Judge.
I'm approaching on Mr. Paez Gonzalez. He's in custody.
IT's on the way. Yeah.
Last name was Paez Gonzalez, right? Yeah, I think it's Paez hyphen. Paez.
Yeah.
Okay. In custody on an indecent and trespass.
I just see the trespass. Maybe it's something else. Okay, indecent.
Right. It's a weird case. What's that?
We.
Yeah, well, the trespass is out of the same transaction as an indecent in this court that was no PC and dismissed. Because there's also a felony indecent, also out of the same transaction, all of those things.
I don't know if you've seen me.
I don't believe so. I think it was magistrate.
Okay.
And then there's an older misdemeanor indecent that so we're still on the oldest indecent and the trespass, different transactions. And there's a felony indecent, same transaction as the trespass. I talked to Chief this morning. I was trying to get these dismissed for sentencing and the felony. He said he's going to email felony and see if he can do that. And we wanted one more setting to figure that out.
It's his 1, 2, 3, 4, 5th. Wow. Okay.
We have a certain case I had.
And it's 199 days old.
That's why we were asking.
So I'll give you a week.
Okay.
But at that time, it's clear trial.
Gotcha.
We can't. And then, do you know what's happening upstairs? Would you say it's happening?
Not set to like May.
For what? But what for?
There was an offer on there. I'm not sure. Let me check the setting, Your Honor.
The problem is that we're at 200 days,
No, I understand.
so it's time to, I'll give you a week to eval.
When we,
I'm just curious to see what no, come on.
Good morning, Your Honor.
Hey, good morning.
The same matter from yesterday, motion to restore property.
Sure.
Sorry, Judge, I haven't listened.
This, would dismiss,
Who's it going to?
Justin Blackburn, Your Honor. It's going back to her. It was her husband's gun.
Was there an agreement to forfeit the weapons part though?
It was basically, the charge was outright dismissed. It was not enough.
So it wasn't due to like a plea or anything?
No, it wasn't a plea or a PTI or anything like that.
Let me see if I can.
Sorry, Judge, this is the first I'm seeing it. I remember talking about it. Just
Judge, may I approach real quick?
Yeah, hi, John D. Come on up.
A couple of things, Judge. I'm glad I caught you before your trial. Two cases. One is Ms. Crawford. She is PTI ready. The only problem is this. She's in the process of getting insurance in order to get the contract. And she's probably going to get it like within the next week. She just didn't have the money to pay for it, but she's going to
She
get
here?
it. Yeah, she's there.
Ms. Crawford, come up.
So if you could just give her another week, she'd probably get insurance and we'll get the
I
contract.
mean, it's 200 days now.
Yes, we just, it's tough for her, but I think she can get insurance, Judge. So,
Hi, good morning.
This is extremely old. It's 200 days.
Yeah.
that's the only thing
Just
left.
to even get the contract?
No, everything's in. They just need either, she's gonna get the insurance. That's the only thing that's.
What about the interlock? She's gonna have to pay for the interlock. She's gonna have to pay the DA fee.
Yeah.
Yeah, she knows, she understands that, but we have to get the contract. But can you do that within all 2 weeks? You remember it's
It's 200 days. I'm not doing 2 weeks.
1 week?
I will give you a week if you don't have it done. But we can't just keep resetting it in hopes that it happens. I mean, I
Right.
have to put a time limit on it.
I'm just now hearing
Yeah.
about this today. Like, I'm just trying to get it done. I don't.
No, the insurance I was flagged, Judge, so,
Yeah.
I mean, it was ready until I followed up with
You
Brenda.
need to get everything finalized and done. Just stay in contact with John so you can met.
Mm-hmm. Okay.
Okay, yeah. And then the other one, Judge, is Mr. Nyla.
And
We've got a offer, Judge, Nila, and I'm not sure if I even have their approach, but while I'm here. Is it getting old? Is it what, past 160?
Let me see. It's 107, so you got.
One more reset for, yeah, I got you. And that's it.
Have a, do you need a translator?
Sure.
You need a translator?
No, Judge, we'll get one.
Can you have him come up, please?
Mr. Lopez? Oh, he speaks English, Judge. Answer yes or no, sir, to the judge. And speak loudly.
State 4, if you ever test positive for anything of this nature, I'm going to put you in jail. Do you understand? You are not to consume alcohol, illegal drugs, unprescribed controlled medications. And I'm going to test you weekly to make sure that you're not using. Do you understand? The next time you test positive, you stay with me. Okay? He ran with testing once a week, please, for him. All right, take a seat for me, sir. Thank you.
Reset, Judge.
Yeah, do a reset, but he's gonna have to come once a week to get tested.
Yes, sir.
I'm gonna do a normal
Yes.
setting. Okay? Yes, ma'am. Thanks. Hi. Hey.
My associate came up there the other day, said that the court wanted me to be up here for this,
What's his last name again?
the client, Javier Marin, and it's off docket. It's 2533. Yeah, 2533-581.
There was an issue. No, no.
So my associate, Mitch Leonard, was up here and he said that the court said it wanted me to.
Yeah, there was an issue. I think it's because it's old, right? So we want to know where you're going. I mean, the case is from October of last year.
So I'll just read you the notes that my associate left. Mitigation packet was submitted on April 16th. And his PTI.
Is this the first was charges?
I believe so, Your Honor. PTI application is currently pending approval.
Are they missing anything on the mitigation packet? I have to give you a cause number. It's not on docket.
You get it? I have it up right here.
John, are they missing anything on the mitigation?
You're not, Your Honor. It looks like we had it uploaded and saved as of yesterday. I'm not sure what the disconnect was. When was it submitted?
416.
416. We're just gonna be waiting on approval. Everything's in the.
Okay, we'll give you a week. Maybe the appearance if it's not done.
Okay, great, Judge.
If there's no answer next week, just because it's kind of old, there's no answer, I'll waive the appearance. If there's an answer, yes or no, we'll have them here, send them to do a TRAS.
Yes, Judge. The reason that I was approaching though was for travel modifications or like a request for travel. He wanted to request travel to the UK for work-related professional development conference departing 4/26 at 9 p.m., returning 5/2 at 11 a.m. And he will not be driving anytime during the trip.
I'm okay with that.
All right, thank you, Judge.
Just, I guess between now and then, hopefully we'll have an answer. Let him know he's gonna get tested when he gets back, so not to use, like, at all.
Hey, Judge, this is off docket, so did you want to do a new setting or can we just keep
Have
you
to
all?
let Preachall know.
Okay,
They know not to call him while he's out.
okay.
Okay, but to let your client know he's gonna get tested, so not to.
Absolutely, Judge. Yeah. All right,
And just let me, Tori.
we'll do. All right, thank you, Judge.
Approaching on Francisco Ochoa.
Okay, let's hear him, Bob.
He's on bond.
Page 24.
So, Judge, the court wanted Mr. Ochoa on docket today, because there was a new case that he was charged with. An assault that happened in the jail. He's currently on bond for tampering. There was allegedly an assault that happened at the jail. Yesterday I came into the court, Richard and I watched the jail video.
Yeah, okay.
There's absolutely zero participation from Mr. Ochoa in the fight in the jail. It's all on video. zero participation. He's clearly in the video sitting down. That's the state. You have to ask the state that one. I have no idea. So, Richard's been, communicating with the felony prosecutor. He hasn't got a response yet. Currently, there's a warrant out for Mr. Ochoa's arrest.
Well, not a warrant. He's being held at no bond on the assault now, right? He's back there, right?
No,
Where is he now?
there's a warrant out for his arrest. He's in the building right now.
Right. I'm not gonna do anything until I know where he is and we have him, right? If he's out on the lam or just out and about, I'm not doing anything until he's here, you know? If you want me to address it and we do PC, I'm happy to do it, but not till he's here. I'm not gonna, he's gonna be here.
Because if he comes in.
I have he's in jail. I'm showing he's in jail for some reason.
So.
Are you not? It shows jail.
I don't, it's January, it's not.
Okay, so I'm happy to go through everything with you, but I'm not gonna do it till he's here, you know, really. And if it is what it is, I mean, he's about as reasonable as he.
I understand.
And if show him, maybe he'll dismiss it
We
now.
just
I
watched
don't
it
know.
again today. We watched it twice. And
He doesn't want to dismiss it?
he wants to communicate with Richard.
Oh, he wants to talk to felony for some reason.
Right. But this is a misdemeanor case where.
Regardless, Mr. Haggard, I never do PC without the defendant being in here to do it, you know, and that just goes with everything. With every single case, I never do PC unless they're here.
Understood.
You know, if you want me to do PC, I'm happy to do it, but they gotta be here. And then we'll do it. And then I'm happy to watch any videos that you have as well. We'll watch it all together and we'll make a decision.
Like I said.
I'm trying to be as reasonable as I can, you know?
All right, thank you.
Sure thing.
Are you on?
All right, you ready?
Darcy? This is Darcy Davis, John. Put your back on.
Good, we have the panel outside. Just go ahead.
Okay, do this and then we'll go. All right. Good morning, Ms. Davis.
Good morning.
Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
facing a minimum of 90 days in jail.
Yes, sir.
Giving up the right to, is this on Docket or not?
It's on Docket.
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
I do understand.
This isn't like Target where you don't like it. Oh man, this is hurting. You can return it. No, once you plead guilty, it stays with you forever. You never change it. If you're not guilty, don't plead guilty. It's just that simple, really. Don't, because you'll always live with regret.
Sir, I was assaulted first.
I can talk to you about that case, right? You're telling me that it's self-defense, then
A trial today?
Yeah.
She's gonna show up.
She will.
Guys, I'm happy to give you more time to discuss it. Just, it's probably not best here. I live stream, so.
We will for tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
I'll pull it
All right, ladies and gentlemen, we are about to bring in a panel. We're about to start voir dire. I need you no talking whatsoever. If you need to talk, go outside. If you want to use your cell phone, go outside. All right, come on, person, come on. Mr. Muhammad,
How you doing, sir?
you're charged with failure to comply with, basically FSGI, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Thank you, Your Honor. On March 22nd, 2025, in Harris County, Texas, the complaining witness went to the police station to make a report for someone that struck her vehicle and failed to stop and give information. On March 24th, 2025, the officer reviewed body-worn camera where the complaining witness stated that while she was at a soccer game, someone struck her parked vehicle. The complaining witness stated that another witness left a note, and that witness observed the defendant strike the complaining witness's vehicle and leave without stopping and giving information. The witness stated the defendant was the coach of the opposing soccer team. The complaining witness stated that they talked to the defendant, but the defendant has failed to provide their insurance information. The officer met with the witness who viewed the accident and administered a photo array. The officer observed vehicle damage from the defendant and the complaining witness consistent with complaining witness and witnesses' accounts of events. The officer observed text of the complaining witness communicating with the defendant. In those texts, the officer observed the defendant state he is responsible for the crash and he has no problem paying for the expenses out of pocket. The complaining witness obtained a written estimate of cost of repair to her vehicle of $1,975.78.
Mr. Mohammed, I'm going to find that there's sufficient probable cause to go forward with the case. Does he have a license? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
He does, Judge.
I'm also ordering you not to go back to the soccer field. Do you understand? If I find that you pick up a new case, if you go back, I will revoke your bond, put you in jail, no more.
Judge, may I? Is there any way we just do no contact with this person? Because in this club soccer world, there's only like 2 to 3 fields that they play on. My daughter's played Albion and there's only like 3 parks that they play out. So can we just?
It's to happen again. And
I understand. Can we do a no contact so that he's not around that person? Because he's the head coach of the soccer team. And we're going to get this taken care of pretty quick. I think they agreed that if he pays restitution, they're fine with it.
how is it going to be possible if they're still playing soccer that it's going to?
I think he can avoid them. These parks are big. There's Dice, Zuby Park.
May I answer her?
Go ahead.
First of all, sir, I've never had contact with the woman who claimed these claims. That's one. Second of all, I never left the scene because I had to attend.
I'm not going to argue with.
No, of course, I understand.
We're not arguing the case.
Sir, sorry, yes, I'm just trying to clarify that there's no contact between me and the or whoever's making the complaint at this moment. I've never had contact with her in my life, so there's no reason for any non-contact going forward, as I said.
Before he's allowed to drive, I want proof that he's got liability insurance, and I don't want you to have contact with the complaining witness. If I find that you get into another accident, if you're a danger to my city, I'm gonna lock you up. Do you understand, Mr. Muhammad? Okay.
Thank you, Judge.
All right, we need to put bond conditions. We need to show proof to pre-trial that he's got insurance, and then we'll allow him to drive.
Thank you, sir.
You mind filing those conditions? Hold, please.
Yes, Your Honor.
Thanks.
June 24th,
Hey. Hey,
Mr. Ochoa is in the courtroom.
I can't do it now. I've got a jury waiting. I mean, really, I cannot sit here. That's gonna take a long time because we're gonna have to watch a video.
Like literally 1 minute.
No, I've got a jury waiting. They've been sitting for waiting. Mr. Haggard, give me a bit of time. We'll take a break in about an hour and then we can get it done. Harold.
We got Mr. O'Neill here from yesterday. Did you want to send him to get tested right now? Or?
Did we talk about getting tested?
Well, that was the one that.
And I remember,
Gonna call for the dad. And he hasn't been able to get a hold of the dad, I don't think yet, but I had some more numbers for the family I was gonna try to reach.
try it and then we can amend the MOA to allow them to go back, but I don't want to unless I know that all parties are okay and they can be separated. Okay?
Just wait.
Yeah. Okay. Thanks. Yes. This is the last one. After this, go.
Judge, on your document
Get the
today,
event so we can start.
on your document today, I have Mr. Hassel, just Hassel, Jasso.
Okay.
And just a question, if because I haven't heard from him in months. Judge.
I don't see a hustle.
Right here with me.
HASSO.
Oh, J.
Wait a second. Holy moly. You need a translate. Hey, we need a translate.
Yeah, she was here. She knew about it.
So, Mr. Santana.
Yes, sir.
You haven't heard from him?
Motion to withdraw, but I'm not sure if you require him to be.
Yes. So do this. SFPF 1 week. Let them know that they are required to hear. If they don't show next week, I revoke the bond. I'll grant you a motion. If they do show, we'll talk about, yeah, okay?
He doesn't answer my calls.
Yeah, yeah, set it for a week, SFPF.
Thank you, Judge.
Yeah. Okay, and then.
Thank you, Judge.
Judge, was that last arraignment, was that?
Yes, no, because I want to make sure that this homeboy's got insurance.
Okay.
I won't be here. Criminal history.
Guys, what do you say?
I didn't say anything that, I think we're good. We're good.
All right, you ready? Yes. Okay. Guys, we're going on the record. Please do not talk. If you need to use your phone, go outside. We're going on the record. No talking. All right, bring the panel in, please.
How long do we have to?
20? 30 max?
30 minutes?
30 max, no more. Mr. Gomez.
How you doing? Yeah, I'm just on a motion to withdraw on our client, but his appearance was waived today.
Then set a SFBF 1 week. He's got to be here.
Okay.
Abel, move your computer because it's
How you doing, Tom?
a camera. So. Or dim it.
And I can't see it.
I mean, but I just don't want it to get on camera. That's it.
Yeah, there you go. No, yes, Judge, thank you. You know, I always said I knew I was getting older, but I didn't know I'd get to the. All right, for the jury.
All accounted for? All right, everyone, please be seated. Good morning, everybody. Thank you so very much for coming. My name is David Fleischer. I am the judge here of Harris County Criminal Court at Law number 5. We are but one of 16 county criminal courts here in Houston. I'm going to go through the top because I don't know what you know. I don't know what you've heard. I don't know what anybody's been told to you. So I'm going to go as if you guys don't know anything. So what are we? We are a criminal court. There are 2 types of criminal courts, actually 3 types. There are district courts that handle felonies. There are county criminal courts that handle Class B and Class A misdemeanors. And then there are municipal/JP courts that handle Class C. If you ever get a speeding ticket, if you get, believe it or not, a Class C assault or something of this nature, you will go to municipal court. Now, Houston, Harris County is so big that we can't just have a municipal court. We have to have outliers all over the city because, I mean, really, from one part of Houston to the other, it takes you 2 to 2.5 hours. And that's probably without traffic. Because of that, we have justice of the peace that are scattered everywhere that handle Class C cases. Now, what are Class C? Those are the types of cases that are punishable by up to a $500 fine. We here in county criminal court handle Class B and Class A misdemeanors. So a Class B is something that's punishable by up to 180 days in jail and or a $2,000 fine. And a Class A, which is the worst of the misdemeanors, are punishable by up to a year in jail and or a $4,000 fine. We have 16 county courts, and then there are 22 district. Actually, there may be more now. Did they add more district courts?
They did.
Yeah. 4. Business is so good down here that they have to add more, which is not a good thing, right? I mean, we try to stop as much as we can, but you know, it just happens sometimes, right? So they've had to add more district courts just because of the number of cases that are they're just popping up. I know that you don't want to be here. I know it's a burden to you. I would rather be playing Fortnite at home too. So I'm sorry to drag you down here. Really, I am. But I need you. You know, statistically speaking, we live in what, 3 million people? 5% of those upon call, 7% of people who are called upon jury duty actually show up. Do you realize that? It's just abysmal. So I'm so proud of you for coming and doing your civic duty. I really, really thank you. And really, if we didn't have you, it would be complete chaos because how would anything function? So really pat yourselves on the back, and for those who are selected, you're going to get a whopping $40 a day and lunch. So thank you so very much for coming. We're here for a trial today, as you very well may figure out. It's a DWI, and I anticipate this case to last for 2 days, today and tomorrow. Is there anyone that cannot be here tomorrow for any reason whatsoever? They've got plane tickets, a doctor's appointment that they've made for months. It's okay. We bring a lot of you guys because I anticipate there are going to be issues. What I really, really don't want is to impanel a juror and then, oh, I can't make it tomorrow. It's okay. Anyone that can be here tomorrow? And please, when you answer up, please do so by your juror number 15. No, just no can do tomorrow. Not just because I've got I just don't want to come or I've got.
Cancel the appointment. I've got a back issue and the doctor has me scheduled for.
Oh, I'm okay with
That's
it.
it. I can
Okay,
cancel it.
not a problem, really. I'm happy that you're here. We try to accommodate as many people as we can. Is there anyone here that doesn't speak English or doesn't understand English very well? It's okay. Anyone. I'll tell you that no matter how many times we do this, I still get jitters in my tummy because I'm not a very good, orator or speaker. So if I fumble my words, I'm sorry. It's a serious case. DWI is something we take here very, very seriously. I don't think that any of the people here disagree about the law. What they disagree about whether the law was broken. And that's why we have trials so that people can listen and make a judgment call. We're not asking any of you to split the atom, do Pythagoras' theorem. All we want you to do is listen and make a judgment call. Really, you in your gut will know if you hear someone testifying, whether they're in left field or outer space or they're just completely wacko, or whether they know what they're talking about. It's just common sense. Is there anyone here that has some kind of experience that they don't think that they'd be able to sit for a DWI trial? You know what? Let's do this. I'm going to let the lawyers get into it because I don't want to start questioning you here. They're each going to get about 20 to 30 minutes to ask you questions. Please let them know because what we don't want is someone who already has a preconceived notion how things should go. All we want you to do is keep an open mind, leave everything at the door in the past, just come in, listen, and make a judgment call. I'm going to first, before I let the lawyers talk, I'd like to introduce them to see if anyone knows anyone and any of the players here. Will you please stand up and announce yourselves? Introduce yourselves.
Good morning, everyone. My name is John Denver. I represent the state. Fleischer, I represent the state of Texas.
Anyone recognize them? Okay, you may be seated. Defense.
Good morning, everybody. My name is Ray Vasquez. I'm representing Mr. Gomez. And assisting me today is Abel Izagiri.
Anybody recognize them? Okay, please be seated. Now, without further ado, I'm going to let you have the floor.
Big judge. All right. Good morning, everybody.
Good morning.
So like I said, my name is John Denver. I represent the state in this case. And like Judge said, it is a driving while intoxicated case. Let's get into it. All right. In this country, the defendant is innocent until proven what? Anybody can say it? Shut it out. Correct. I'm the only person that can do that. Nobody else has to do that. Defense doesn't have to do anything. It is completely our burden, the state's burden, to prove that to you. So to do that, we have to do a couple things. We have to show, beyond a reasonable doubt, that the defendant, on or about October 6, 2024, in Harris County, Texas, and like I said, the defendant, operated a motor vehicle in a public place while intoxicated. Right? Simple enough, pretty straightforward. We have to prove each and every one of those beyond a reasonable doubt. We'll talk about that in a little bit. But first, I want to talk about intoxicated. What does intoxicated mean? Anybody have any ideas? You can just shut it up. Very good.
Under the influence.
Under the influence. All right. Anybody else? Strong. Yeah. Pretty straightforward there. But let's talk about the legal definition. So there's the legal definition is that intoxicated means the loss of the normal use of your mental faculties due to the introduction of alcohol or drugs, or that you've lost the normal use of your physical faculties due to the introduction of alcohol or drugs, or that you have a blood alcohol concentration of 0.08 or higher at the time of driving. Now, has anybody ever seen a drunk person?
Yes.
How did you know they were drunk?
Staggering.
Staggering. Okay, what else?
Slurred.
Slurs. All right.
Slurred speech.
Slurred speech. Anything else?
Talk a lot, smack.
Talk about smack.
Irritable.
Heard that one before. Irritable. That's another good one. All right. Did you know, anybody who did you know what their blood alcohol concentration was?
No.
But you still knew they were drunk, right? So, and what's important to note here, I don't have to prove two of these. I only have to prove one of these, right? So if I show you one of them and I prove it beyond a reasonable doubt in your mind, right? That means I proved that element. They were intoxicated, right? But you don't always have necessarily 0.08, right? But like you just said, there's a whole lot of ways to be able to tell if somebody's drunk. So if I show you one of the other two, and I don't give you a blood alcohol concentration, then, but I do prove beyond a reasonable doubt, you still have to find the defendant guilty, or to show, or at least find that I proved that element was to me. If I prove all my elements, right? Let's say for this hypothetical, I prove every single one of my elements beyond a reasonable doubt, including this one. But let's say I don't show you that they were above 0.08 at the time. Is there anybody here that would be incapable of finding the defendant guilty, even though I proved all of my elements here? Anybody? It's okay. I just need. No? All right. All right. So, got a little story for you. So these are my two granddads, right? Over here on the right, this is Mike. On the left is Don, right? So Mike is a wine drinker, right? And as soon as he opens that bottle of wine, as soon as he smells it, he already starts getting giggly. You can look at him and he looks like he's drunk, right? Automatically. As soon as he sniffs that wine, as soon as he smells it. And then you have Don. Don is a whiskey drinker. And Don can drink all night long. And he never changes, right? He's the exact same, he's telling the exact same joke, acting the exact same way, and you never know he's drunk. So let's say that one night you're hanging out with Don, and you watched Don, and you watched him drink whiskey all night. And Don turns to you and he says, I'm a little hungry. Let's hop in the truck, run a Whataburger. I'll drive. Is there anybody here that's going to get in the truck with Don? No. Why not, though? He looks fine, doesn't he? You can't tell.
Yeah, but if you saw how much he was drinking, that's just a telltale sign that it wouldn't be in your best interest.
So, even though he might not look drunk, but you knew that he drank a lot.
Is he capable of driving?
So, well, for the purpose of this hypothetical, he's drank a lot. we're just gonna say
My
that.
question is he capable of driving?
Well, for the purposes of this hypothetical, let's just stick with the fact that he's drank a lot of alcohol. But you don't know exactly how much.
The
So,
reason why I asked that question, I got an uncle who can drink all day and still drive this smooth.
okay,
So that's why I asked the question.
so if, let's say that uncle, would you get in the car with that uncle?
Maybe, maybe not.
Depends on the driver.
Yeah, depends on how I'm feeling that day.
Okay, all right. So let's say that I was able to show you that, you know, a certain. Let's say that I proved beyond a reasonable doubt that the defendant was a public fire, right? But you thought from whatever you saw that the defendant was still capable of driving. Like that uncle was driving.
Yeah.
Would you still be able to find the defendant guilty and follow the law that says that if I show you he's above the .08, you've got to find the defendant guilty. If I prove to you beyond a reasonable doubt, you still be able to find him guilty.
I'm gonna object, Your Honor, that's my question.
Restate the question, please.
If I prove to you beyond a reasonable doubt that the defendant was above a .08 and was intoxicated by the law, and I prove to you all my other elements beyond a reasonable doubt, would you still require me to prove that he was incapable of driving, like you were talking about, even though I proved all my elements beyond a reasonable doubt?
First of all, I don't recommend he stop driving.
But just yes or no,
Yeah,
you'd be able to find him guilty,
yeah.
or you need me to prove more?
Well, I mean, his blood that was, what, 20? Yeah.
You'd be able to find him guilty?
Okay. Still a commitment issue, Judge.
Please don't ask just these commitment issues. Ladies and gentlemen of the jury, remember, back in the old days, we didn't have all these things. There were no blood tests. There were no breath tests. There was no videos. With the advent of science, with new technology comes better aids, right? But at the end of the day, common sense dictates. You know what you see. You know what someone looks like when they're a particular way. Just use common sense, right? Everything else is just.
All right, let's move on with it. All right, so I talked a little bit about beyond a reasonable doubt, but what does that mean, right? Surely there's a definition. Not so much. But what it is, I can tell you essentially what it doesn't, right? It does not mean beyond all doubt. It doesn't mean beyond a shadow of doubt. And it doesn't mean beyond a certain number of percent, right? 95% sure. We don't use that, right? You just have to base it on your common sense and your life experiences. Okay? So, for this next exercise, I'm going to show you a picture. And it's going to be blocked out. And then I'm going to go through each slide, and each slide is going to reveal a little bit more of the picture. Okay? So, once I get to a point where you see enough of the picture, where you think you know what it is, beyond reasonable doubt, I'm going to ask that you raise your jury card. All right, has everybody got that? Anybody have any questions about that? Everybody good? All right. All right. Anybody know what this is? The whole picture, sorry. No? Anybody have any guesses? It's a place. All right, I can tell you that much. It's a place. Anybody know what place we're at? Just based off that little sliver? All right. Good. Anybody now? It's got a specific name. It's got a proper name. All right. Anybody now? Okay, but are you beyond reasonable doubt? Are you sure beyond reasonable doubt that is what you're saying?
Beyond reasonable doubt, not yet.
Okay, all right. Just when we're beyond reasonable doubt, all right, everybody? All right. All right. Anybody now? All right, go ahead and raise your jury card if you are good beyond a reasonable doubt. Raise my eye, please. All right. Don't put your cards down now. All right, who's left? If there's anybody left. All right, now, anybody? Those still left? Okay. All right. So yes, it was Stonehenge, all right. It was a good guess. But you see, that's kind of how beyond reasonable doubt works, right? So when we went back here, here, you said you thought it was Stonehenge, but you weren't sure, right? Why weren't you sure? What was the feeling that you had?
Well, I've seen, a lot of pictures of Stonehenge. It look like that there are some copies elsewhere.
Okay.
That are smaller scale.
So, but when we got to here, you saw that, and that's when you decided. You thought, okay. So everybody can kind of see, right? I still don't have the full picture, right? There's a lot missing. Like you said, there's copies, there's other things elsewhere, right? But if I have enough of that picture, then I can still say that it's beyond reasonable doubt, even though I don't have everything that's there, right? And that's kind of how trials work. That's kind of how evidence works, right? There's might be some things that we're just not going to know. But it can still be beyond a reasonable doubt if I show you enough of that picture. Does that make sense, everybody? All right, so let's talk about evidence, right? We've already said it's a DWI case. So what kind of evidence do I expect to see in this case? Anybody, you can start anywhere. We said crash car, maybe.
Maybe a video catching speeding.
Okay, what else?
Maybe an offense report.
Okay,
Like sobriety test results.
okay.
Witnesses.
Eyewitnesses, okay. Anything else?
Blood alcohol test.
Okay. Anything else?
Medical history.
Those are all good answers. Now, like we said, and we talked a lot about beyond reasonable doubt. And we talked a lot about the elements. But is there anybody that would need a specific type of evidence in a DWI case, right? You said blood evidence. Is there anybody that would need a specific type of evidence before you could find the defendant guilty, even if I proved all my elements beyond reasonable doubt?
Did he hit someone?
You would need to know that evidence? Or
Did he hit someone?
did he hit someone? If he didn't hit someone, would you be able to find him guilty? Even if I proved all my elements beyond reasonable doubt? Possibly.
Yeah.
Okay. Anybody else need a specific type of evidence? You said you need to know the speed.
Right.
So,
Could have been people know the speed of traffic, causing an element to drivers behind it.
okay, so if I didn't have what speed you just going, but I proved all of my elements beyond reasonable doubt, would you still be able to find him guilty?
Maybe.
Maybe, and I just said yes or no, and I'll repeat that for the record. No, you would not be able to find him guilty, even if I proved all of my elements beyond reasonable doubt, because you didn't know what speed. he was going. Thank you. Anybody else? Juror number 2.
I think I need a report for breathalyzer, all that.
Okay, so even if I prove to you, because we already talked about, remember back there, we talked about the definition of intoxication, those are all ors. I only have to prove one of those two to meet that element, right? So you're saying that even though I proved my case beyond a reasonable doubt, if you don't see a blood alcohol test, you're not going to be able to find it.
Maybe a brush, Judge.
The alcohol.
Sure. Repeatedly trying to get them to commit to something, you know? Either rephrase it or, you know.
I can rephrase that question. I was trying to clarify exactly what you're saying. Well, in fact, I understand what he's trying to do, which is that he's trying to get, angry from so I think it needs to be reappraised to where it's not a commitment. Those seem to make my questions through that would be my opinion.
Yeah, great. It is, if you're trying to commit them to something, please should. All right.
She can hear, Judge. She can hear.
Oh. Okay, just.
With this commitment, watch this. Yeah. For some reason, I don't see a number. I can't find something guilty.
Just you go, look, I've given all the elements. Can you find them?
Yeah. Okay, I just want to make sure.
Are you okay with that?
That can, I think it's good. I think
What would you suggest?
it could would be probably better than it can.
Okay, so clear as you find them guilty. If all my elements met, just don't keep harping on it. Start getting into the blood, start into the blood test, right? Then it gets into commitments. You have enough elements, which you do. All right.
All right, let's get back into it this time. So come back to you. So even if I prove to you, beyond a reasonable doubt, that it was impossible, don't see a specific type of evidence, could you still find the defendant guilty?
Jurors, all you need is common sense. If you see someone, they're falling down, urinating all over themselves, just use common sense. You know what someone is when they're not. Like I said, remember, in the old days, how did they ever find someone guilty of a DWI? We didn't have these kind of stuff. So they just used common sense. Whether there was video, whether there was not, whether there were people testifying, when you hear someone, whether they're in outer space or not. Just use common sense. Please.
Thank you, Judge. All right, let's move on. Okay, let's talk about witness credibility. So, in the state of Texas, right, no matter what someone looks like when they walk through that door back there and get up on the stand, they all start at the same line, right? Doesn't matter if it's the Joker, Bruce Wayne, Nun, Snow White, or law enforcement, right? They start at the exact same line, regardless of what they look like, how they're dressed. It doesn't matter until they open their mouths on that stand and start talking. Then you can make judgments about credibility. Okay. So, is there anybody here that would give more credence to someone's testimony just because they come in dressed in a uniform with a police officer? Is there anybody here that would give them more credence? Give them more credibility? No? Okay. What about less? No? All right. Okay. Almost finished up here, y'all. So we have in Texas a two-part trial system, right? The first part is guilt innocence, right? That's what you're here to do. You are only here to decide if they are guilty or innocent. There's only two options. For punishment, you won't be concerned with that. All right. So you'll have no voice in the punishment. Is there anybody here that would be incapable of finding the defendant guilty if you have no say whatsoever in the punishment that he receives? Nobody? Everybody's good? Okay. Anybody else? No? Just making sure. All right. Okay, so for this next question, it's going to be a little different. All right, so here's what we're going to do. It's what we call a scaled question. So what we'll do is I'm going to go down the line. I'm going to say juror number 1, and then you're going to say your answer, say it loudly and clearly so the court reporter can hear. All right, so I'm going to ask, not yet, but I'm going to ask, how important is it to you that we prosecute DWI cases? All right, here's one. How important is it to you that we, the state, prosecute these types of cases? Right? If it's not important to you, juror number 1, you'd say 1. If it's somewhat important to you, then you'd say 2. Again, you see how that goes. It's important 3, very important 4. All right. So I'm going to go down the line and just say juror number 1, and then juror number 1, you'll answer with whatever number corresponds to your answer. Does that make sense? Everybody got that? Anybody have any questions about that? Okay, great. Let's start. Juror number 1. Juror number 2. 1. Juror number 3.
4.
Juror number 4. 3. Juror number 5. 3. Juror number 6. 4. Juror number 7. 4. Juror number 8. 4. Juror number 9. 3. Juror number 10. 4. Juror number 11.
4.
Juror number 12.
4.
Juror number 13.
3.
Juror number 14.
4.
Juror number 15. 4. Juror number 16. 4. Juror number 17.
3.
Juror number 18. 2. Juror number 19.
4.
Juror number 20. 3. Juror number 21.
4.
Juror number 22. 3. Juror number 23. 3. Juror number 24. 3. Juror number 25. 3. Juror number 26.
3.
Juror 27.
4.
Juror 28. 3. Juror 29.
4.
Juror 30.
3.
Juror 31.
2.
Juror 32.
Definitely 4.
Juror 33. 4. Juror 34.
4.
Juror 35.
4.
Thank you. All right, and then we have one more, and we all kind of got out of that work last time, so that was great, y'all. So we're gonna do that one more time. And this time, it's a statement, and if you agree, you're 4. If you somewhat agree, you're 3. Somewhat disagree, 2. Strongly disagree, 1. All right. The statement is law enforcement is doing a good job in my community. All right. So everybody good on that? Everybody knows how we're doing that this time? Okay, great. All right. Juror number 1. 3. Juror 2. 2. Juror 3.
3.
Juror 4. 3. Juror 5.
3.
Sorry.
3.
Juror 5. Juror 5 indicated. Juror 6. 3. Juror 7. 2. Juror 8.
4.
Juror 9. 3. Juror 10.
3.
Juror 11.
4.
Juror 12.
3.
Juror 13.
3.
Juror 14.
3.
Juror 14. Sorry, excuse me. Juror 15. 3. Juror 16. 3. Juror 17.
2.
Juror 18. 1. Juror 19.
2.
Juror 20. 3. Juror 21.
4.
Juror 22. 4. Juror 23. 2. Juror 24. 2. Juror 25. 1. Juror 26.
3.
Juror 27.
3.
Juror 28. 3. Juror 29.
3.
Juror 30.
3.
Juror 31. Juror 32.
3.
Juror 33. 3. Juror 34.
3.
Juror 35.
3.
Thank you, everybody. All right, so.
2 minutes.
2 minutes, thank you, Judge. Just one last question. Does anybody have any moral or religious reason why they can't sit in judgment of others? Anybody? No? Anything? All right, well, thank you so much, y'all. I look forward to talking to a few of y'all here in a little bit.
All right, thank you.
May I have a moment to set up, Judge?
Sure.
We having fun yet? Of course we are. The answer is yes. It's always fun, right? All right, my name is Ray Vasquez, like I told you. I represent Mr. Gomez. I'm going to kind of go through some of the similar stuff the state went through, just probably expand on some stuff some more. Except now it's not working. There you go. Here to help, Your Honor. All right, got a little attitude. All right. Okay. All right, so a couple of things Tom told you. It's the state's burden, right? Does anybody disagree that the state has the burden to prove the case beyond a reasonable doubt? They're gonna say, you know what, Ray, I want you to get up and I want you to tell me why your client's not guilty. Right? Is anybody gonna say, Ray, I need you to tell me why your client's not guilty? Raise your hands. Go ahead and raise your black card real high. I know somebody's gonna say that. All right, jury number 3, you would want to hear what our defense is, right? Even though it's the state's burden and the state's only burden, I could sit here and do nothing, right? Okay, everybody's heard of the Fifth Amendment, right? What is the main crux of the Fifth Amendment? Right to remain silent, right? Anybody watch cop shows? When you see those cop shows, what's the first thing they do when they arrest somebody? Read you your Miranda rights. What's the first word of the Miranda rights? You have the right to remain silent, right? Which means I can sit here and do absolutely nothing, right? Does anybody disagree with me? Juror number 3, you disagree with that?
I feel like, being with personal experience, I need to know why the defendant is here in the first place, because there are plenty of people that drunk while under the influence, but what was he doing specifically that got him in this situation?
Okay, well, you understand though that as he sits here today, he is presumed innocent, correct? Okay, everybody, does anybody disagree with that? Presumption of innocence, right? Okay, so what you're saying is you would have to hear from him in order to make a decision on this case, is that correct? Yes, I need you to say it loud, please. I'm sorry. Okay, juror number, I'm sorry, I think you're 14. You said the same thing, I saw your card go up.
I would just like to hear the defense, and you, basically trying to debunk basically what the prosecution is saying.
Okay, but you understand it's not my burden to do that, correct? So if we don't put on a defense, if we just sit there and remain silent and say absolutely nothing, you would still not be able to enter a judgment in this case?
I would be able to.
Okay. Anybody else feel that way? Juror number 32. You feel that way?
Yes.
So you would have to hear from the defendant before making a decision?
Yes.
Okay, and if he doesn't testify, you won't be able to make a decision one way or the other?
I think I'll be able to, but I still want to hear the other side.
Okay, I'm sorry to do this to you. Anybody ever, who's married? Where are my married people at? All right, so juror number 32 just gave us a perfect example of what I think, or maybe, or something like that. I think somebody earlier had said maybe, right? All right, all you married folks, and even if you're not married, you have a partner or whatever the case may be, your partner says, I want to go to Vegas this weekend. gonna hang out with the boys, right? And you say, were you gonna be faithful? I think I can, or I think I will, or maybe, right? Are you gonna be satisfied with that answer?
No.
Right? Nobody's gonna be satisfied with that, right? You wanna know, right? I'm sorry to do this to you, but we need to know. Okay, so I need either a yes or a no from you. So if the defendant doesn't testify, would you be able to complete a finding in this case? Or would you require the defendant to testify, I guess is what I'm saying.
Yeah.
You wouldn't require him to testify? Okay, is anybody that would require him to testify? Raise your flag real high. Alright. So it's the state's burden, right? Which means they have to prove everything to you. Everybody understands that, correct?
Right.
Alright. Unless proven what? So he's presumed innocent unless proven guilty, right? That word is important to me, unless, right? It's not until, everybody thinks it's until, right? Until means he has to be guilty, right? It's unless proven guilty, which means the state has to prove it to you beyond a reasonable doubt, right? Everybody's good with that?
Yes.
And they have to prove what part of their complaint do they need to prove? Just a little bit of it, portion of it, or all of it? Anybody? All of it, right? Not just each one, and you can't just say, yeah, I think that's true. It has to be, each element has to be proved beyond a reasonable doubt, right? Juror number 10, I see you shaking your head.
Yes.
Am I correct in that?
Yes.
Thank you. Okay. So, y'all seen these signs on the road, right? Everybody's seen the signs there everywhere, especially come 4th of July weekend, Memorial Day weekend. We just see those things, the text stop signs come up and they're just automatically saying, drink, drive, and go to jail, right? In fact, the prosecutor even told you, kept saying drunk, 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 right? Drunk is not the law, ladies and gentlemen, right? Drunk is not the law. The law is driving while intoxicated, right? So drink, drive, go to jail, that's incorrect, right? Is it still legal for you to go out, have 2 glasses of wine or 2 beers at dinner and still get behind the wheel of a car? More likely than not, right? Unless you're 5 foot nothing, 100 and nothing, then 2 beers might get you beyond the limit,
Right.
right? But 2 beers, alcohol has raises your blood. 1 beer or 1 glass of wine or 1 shot raises your alcohol level 0.02, right?
Objection, Your Honor. You're stating the jury. Can we approach?
Hold on, what was your question? What was your question?
I was explaining how alcohol affects the body. Raises the blood alcohol 0.02 per gram.
What's your objection? I mean, probably better not to get in statistics now, you know? Okay. Fine.
All right, so based on your weight, size, all that good stuff, you could potentially be okay with 1 to 2 beers or 1 to 2 glasses of wine. Does anybody disagree with that?
It goes by your weight.
Goes by your
amount
weight
of time.
and the amount of time. Okay. Does anybody disagree with that? Yes, sir. Juror number 22.
Yeah, unless you're disagreeing with what the state said earlier, there were 3 elements, only one of which needed to be proven. And the other 2 have nothing to do with measured alcohol content.
Correct. Right. But we get, yeah, I'm sorry. And I'll clarify for you.
Yeah.
Okay, so the prosecutor kept saying drunk, 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 right? Do most people, on average, with 1 to 2 drinks, are they just completely drunk, falling over, staggering, can't speak, anything like that? Right? No?
I don't know alcohol.
Or you don't drink at all.
I cannot.
So if you have a whiff of alcohol, you might feel that way, right?
If I have a couple of sips of margarita, I'm out.
Okay. All right, so it depends, right? But on average, 1 to 2, you're not gonna be stabbing all over your plate, so you're not gonna be urinating yourself, anything like that, right? So there are exceptions, of course, but for the most part, most everybody's not gonna do that way. Does anybody disagree with that? All right, so again, drive sober or get pulled over, drink, drive, go to jail, drink, and go to jail, right? That's what we've all been taught, and we know that's not the law. It is not illegal to drink and then drive, as long as you're not intoxicated. And as Juror 22 pointed out, there are 3 ways to prove intoxication. Right? The state told you what those 3 ways were. They don't have to prove all 3 of them. They just have to prove one of those 3, right? But like juror number, I'm sorry, what was your number again? 27. She has 2 sips. She might lose her mental faculties, right? She might lose her physical faculties, right? So that would be enough for her to technically be intoxicated under the law, even though she may not be drunk, as the prosecutor kept saying. Does everybody see the big difference? Right? Does anybody disagree that there's a difference between intoxicated and drunk? All right. All right, so going to my drinking patterns, going to juror number 27 again. Juror number 27 said she doesn't drink at all, right? So she would be a D or an E. Okay. Now, sometimes we have to cover your alcoholics. It would be E's, right? Okay. So I'm going to go down each line, all right, and you're going to tell me what your drinking patterns are, and just go from there. So A, you drink regularly. That doesn't mean you drink every day or anything like that. But like me, Easter weekend, I had a few beers over the weekend. Everybody was over at the house. We were by the pool. And I had a couple beers. Right? I would consider that regular. Right? Occasionally, only on social events, things like that. Rarely, you know what? If I feel like it, maybe I'll have a sip or 2. Never, like juror number 27, or not anymore. Okay? Everybody good with that? Juror number 1. C. C. Juror number 2. B. Juror number 3. B. Juror number 4. E. 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 Juror number 5.
C.
Juror number 6. B. Juror number 7.
C.
Juror number 8.
A.
Juror number 9.
C.
Juror number 10.
B.
Juror number 11.
B.
Juror number 12.
E.
Juror number 13.
A.
Juror number 14.
B.
Juror number 15.
C.
Juror number 16.
C.
17.
C.
18.
A.
19.
C.
20.
E.
I'm sorry? E. E.
E.
E. Yes, E. Juror number 21.
C.
C. Juror number 22.
C.
Juror number 23.
E.
Juror number 24.
C.
25.
B.
26.
C.
27.
B.
28. I'm sorry, what was you said? D. She's my 2 sips and she's out. I'm sorry.
That's all.
You were self-admitted to it, so, I mean. 28, I'm sorry, what was your answer?
B.
B. 29. 29 was A. 30.
B.
31.
C.
C. 32.
A.
A. 33.
A.
34.
A.
35.
B.
Oh, my party is in the back. We gotta hang out after this. All right. I don't want to get too specific on any of this. But has anybody ever had any issues with an accident while they've had alcohol in their system, or an arrest? Or has anybody dealt with alcoholism? If you don't feel comfortable talking about it up here, if you want to approach afterwards, just raise your placard card and we can talk about it at the bench afterward. If not, if nobody's had any issues, then I'll just move past this. Anybody?
Personal issues.
Personal issues, correct issue. Okay, turn number 2. Which one? If you mind, or do you want to approach afterward? Approach after. Okay. Juror number 13? After. Okay, anybody else? 20 and 32. So I'll get 2, 13, 20, and 32. Approach afterward. Is that what y'all want to do?
I know.
Okay.
Alcoholism.
Alcoholism? Okay. And 20, did you want to approach afterward? Alcoholism? All right. Who's heard of MAD? Mothers Against Drunk Driving. Raise your hands if you heard of the class. All right. Anybody donate to them or anybody participate in them, anybody give money to them or anything to that effect? Just raise your placard card for them. 15. Donate?
Family, yeah,
Family?
my wife did,
Okay.
but we did.
Gotcha. Anybody else? All right. All right. Now comes the fun part. I'm gonna knock you out. Who's a cop? I know somebody in here is a cop, probably. Anybody? Police officer? Nobody's a police officer, former police officer? All right, anybody have family that's a police officer or a district attorney? Juror number 2. You have family? Brother? Okay. Anybody else? Juror number 7.
Uncle.
Uncle. Juror number, anybody else on the first row? Juror number 9.
Yeah, cousin.
Cousin. Juror 21.
Cousin.
Cousin. I saw another placard on the second row. Anybody else? Juror number 29. Uncle? Yeah. Okay. So, going down the line, juror number 2, with your brother being a police officer, would you automatically feel like a police officer is automatically credible? And would you give more weight to the testimony of a police officer in a situation like this?
I feel like I would, because they've had training.
Okay, and do you feel that that would not make you a fair and impartial juror in this case? And again, I gotta ask the question of yes or no?
Yes.
Yes, okay, so you cannot be fair and impartial, correct? Okay. Juror number 7, same questions to you. Anything about your uncle being a police officer would automatically give you rise that a police officer is automatically credible?
I would say yes.
Okay, and do you think?
Well, you'd ask the more credible.
Okay, and do you think that you would not be able to be a fair and impartial juror just because of your?
No, I think I could still.
Again, I can't accept. I think it's yes or no.
Repeat your question.
Do you feel you would still be able to be fair and impartial even with the relationship you have with your uncle?
Yes.
So you can be fair. Number 9.
Yes.
Yes, you can be fair and impartial. 21.
We'll be fair.
Okay.
Yes.
And 29. Yes? You said it was your uncle, right? All right, anybody related to or ever been a prosecutor in this county or any county? I know I've got Harris County up there, but any county, anybody related to or been a prosecutor themselves? Raise your hands. No? All right, big deal. Anybody been a defense attorney? Who's my lawyer? Where's my lawyer? There he is. What kind of law you practice, juror number 1? Corporate law?
Yeah.
Okay. All right. Wow. I gotta make the font a little bigger on that. Presumption of innocence. I know I harped on this early on. I'm gonna harp on it again. Why? Because it's extremely important, right? 0 being completely innocent, 10 being guilty, and he's here for a reason, so he's got to be somewhere in the middle. Maybe he's guilty, maybe he's not. I'm going to ask you to give me an answer based on 0 to 10. Just that answer, okay? Everybody understand that? So 0 being completely innocent, you're going to automatically assume he's innocent. 10, you're going to think he's guilty already without ever hearing any evidence, or you can fall somewhere in the middle. All right? Any questions on that?
I don't either. I don't know.
Okay. So I'm going to ask you.
How do I know? I mean, just because you're saying
Here.
because he's here?
I'm asking, that's what I'm asking you. So
Just.
I'm gonna ask you.
I don't think that's a fair question.
No, it's not.
No, not gonna work.
Okay, so they're automatically assumed innocent, correct? Right? Did everybody understand that? There's a presumption of innocence, right?
Under the
I'm
law.
asking, under the law, there's a presumption of innocence. I'm asking you your personal feelings, whether or not you can go a 0, or you're gonna be
I
at a
have
10,
no evidence.
or somewhere in the middle,
I have no evidence.
as it stands right now, sir.
I have no feelings about it because I.
Okay, so you would be a 0 then, right?
No, I don't think he's presumed innocent. I don't think he's presumed guilty.
Okay, you understand that the law requires that there's automatically a presumption of innocence, correct? Even as we sit here right now, he's presumed innocent, right? That's the law. Do you understand that?
You're asking me to say what I think about this case when I hear.
I'm asking about the presumption of innocence. Right? So,
We're here because of this case.
correct. So I'm asking,
And you're asking me how I
Presumption of
feel about his guilt or innocence.
Correct.
About what the law says.
no, I'm asking how you feel about the law and whether or not you can give him the presumption of innocence
Is
as
how
we
you
sit
feel
right now.
about his guilt or innocence.
Right, as we sit right now.
Answer that question.
Okay, as we sit right now, I'm asking for either a 0, a 10, or somewhere in the middle. Okay, does everybody understand that?
Yeah.
Okay. And what's your number, sir?
23.
23. Thank you, sir. All right, turn number 1.
You're up.
Turn number 2.
5.
Turn number 3.
5.
Turn number 4.
0.
Turn number 5.
2.
And I'm sorry, that was a 2? Turn number 6.
0. I'm sorry, Ray, can you do number 4 again?
1 was 0, 2 was 5. 3 was 5, 4 was 0.
Okay.
Okay, I was on 6, 7. Turn number 7.
0.
Turn number 8.
5.
Turn number 9.
5.
Turn number 10.
5.
Turn number 11.
8.
Turn number 12. Turn number 13.
5.
Turn number 14.
0.
Turn number 15.
5.
Turn number 16.
5.
Turn number 17.
5.
Turn number 18.
0.
Turn number 19.
0.
20.
0.
21.
5.
22.
0.
23.
5.
May we approach, Judge?
We got a couple minutes left, so. I think that's a misleading question. You know, it's a misleading question because people would like to be fair. They don't understand the question. They're gonna say 5 because they want to be fair, like right in the middle. You know, a lot of people didn't understand the question as it was. And they're arguing with you, they just don't understand it. You know? I don't know if you've busted anyone yet, and so we can move it further. People don't understand it, and they clearly had like 4 to 5 people that didn't understand it, even after you tried to go over it 3 times. So I mean, continue with it. Let's just continue with it and go. Okay. We'll bring him up. I don't think it was.
All right, where was I? 24. 25.
0.
26. 27. 28.
0.
29. 30. 31. 32.
0.
33.
0.
34.
0.
35.
2.
Okay. What's that say? Jumping to conclusions, right? Kind of like with our Stonehenge picture, we haven't seen the whole thing, right? We just assume that says jumping to conclusions, right? That's not what it says at all. Okay. So, yeah, how do you pronounce it? I have no idea, right? But everybody just assumed you saw a little bit and you knew, hey, I know exactly what that says, right? This is reasonable doubt, ladies and gentlemen, right? Just like the Stonehenge picture, you gotta see the entire picture before we get there, right? Reasonable doubt. Now, prosecution showing you that Stonehenge picture, that's pretty good, right? But it got about halfway, and then right about halfway, everybody can see exactly what it was, right? Well, halfway gets us, oh, that's not gonna show up. That gets us to about reasonable suspicion or maybe probable cause. Everybody sees the steps, right? My corporate lawyer, what's the standard in a civil case? Preponderance of the evidence, right? Just a little bit over halfway, right? Anybody know who CPS is? What CPS does? Right? They take away your kids.
Objection, Your Honor, received. Chairman, approve.
Overruled. Continue.
CPS takes away your kids, right? What's the standard for CPS to take away your kids? Anybody know? What's the standard as far as proof is concerned? Clear and convincing evidence, right? So right between preponderance of the evidence, my civil lawyer over here, which is when you're arguing about money, you just gotta be like a little bit above what you know, the evidence is a little bit there, right? Take away your kids, it's a little bit further. But to find somebody guilty, you have to get 2 more steps, right? Everybody see that? So you gotta get beyond clear and convincing, which is take away your kids. To the next step, reasonable doubt, even if they get to that step, they still have to make it to the next step, which is reasonable doubt, right? You have to get all the way up that staircase. Does anybody have a problem with that? Does everybody understand that? All right, so I think I'm about out of time. Thank you all very much for being here. Jury service is a very important aspect of our criminal justice system, our judicial system altogether, but especially in our criminal justice system. So I do thank you all for being here. And with that, I'll stand down. Does anybody have any questions for me?
Did you drive after drinking your beers?
Sorry?
I said, did you drive after?
I was at home. I stayed home. Yeah, I was at home. Took a shower and went to bed. All right, thank you all very much for your time.
Ladies and gentlemen of the jury, DWI is extremely serious and we take it seriously. Both the sets of the lawyers got up to ask you questions to see, would you be the proper juror in this type of case? Because not everybody is, and it's okay. We get it. You have things that happen in your life that may really have a profound impact on you where you may not be a good juror for a certain type of case. We get that and we understand it. And that's why they're up there asking you questions. It's not to trick you, this to see. Have you already found this defendant guilty by virtue of just walking in here? That's what we want to know. Will you keep an open mind and listen to everything? Don't make a judgment call. Don't listen to all this jibber jabber about it. No. All you do is you listen to testimony, you look at evidence and make a decision. I told you at the beginning, it's not rocket science. We're not asking you to do Pythagoras theorem. No. Listen, in your gut, you will know when someone really knows what they're talking about, and just make a judgment call. That's all there is to it, right? If you have things that have so impacted you, okay, let us know. We'll bring you up individually. We'll talk to you. And if you're not the best juror, that's okay. Perhaps you are for the next case. With that, lawyers, come on up. Let's do it. Veneer. What's happening now is each of the sides gets peremptory challenges. What that means is that they get to strike nearly anyone on one of you guys for some reason that they didn't like. Nearly any reason, right? There are some exclusions, obviously, but you didn't look them correctly, you didn't give a right answer. So each of them get a certain number of strikes that they make, okay? They get a certain number of strikes, defense get a certain number of strikes, and then when they're done, because I'm only giving them 5 minutes, they're going to give their strikes to us. We reconcile that with the other challenges that have been made. And with that, the first few get impaneled into the pool. Any questions? Okay, so give me 5 minutes. Hopefully it's 5, and then you'll be out of here. Does anybody need a bus pass or anything of this nature? Okay, just one person? Anyone else? Okay. Work excuses? Okay, we'll have those for you too on the way out as well. All right, when you hear your name called, please stand and take a seat in the jury box. Oh, wait, hold on. Just your number,
Just number.
no name.
Okay. Juror number 4.
You please rise and come to the jury's box. You've been selected.
Juror number 10. Juror number 13. Juror number 14. Juror number 16. Juror number 17. And juror number 19.
All right, ladies and gentlemen of the jury, please rise. So everyone can be here tomorrow, correct? Everyone speaks English, right? You understand? We good? Haven't heard anything from you. Wonderful. I believe it or not, we've had it different. So, all right, will you please raise your right hand? Sworn. Do each and every one of you solemnly swear that you will true verdict or render in the case that's been sworn on to today? All right, you may be seated. Ladies and gentlemen of the jury, you're done. Thank you so much for coming. I hope this hasn't soured your experience, that you will show up for next service.
You're gonna get everybody outside. Do their work.
We're done. Yes. Are you ready?
Yes, Judge.
Guys, please rise.
In cause number 2532700 in the Harris County Criminal Court at Law number 5, in the name and by the authority of the state of Texas, comes now the undersigned Assistant District Attorney of Harris County, Texas, on behalf of the state of Texas, and presents in and to the Harris County Criminal Court at Law number 5 of Harris County, Texas, that in Harris County, Texas, Odir Alberto Gomez Santamaria, hereafter styled the defendant, heretofore on or about October 6, 2024, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, against the peace and dignity of the state.
All right, which the defendant pleads.
Innocent.
Okay, please be seated. Ladies and gentlemen of the jury, we are done with you guys for today. We will reconvene tomorrow back at 8:30 in the morning here. We have a jury room out there. I will have Deputy Echegoyen as your point of contact. If you have anything that you need, any questions, comments, anything, he will be your point of contact. You can ask him and we can always remedy any kind of situations. When you out there tonight, please do not do any independent research. Do not talk to yourselves about this case. Don't do any investigations, anything like that. We just want you to come in tomorrow, listen to the evidence, and then make a judgment call after both sides have closed. Anyone have any questions? Okay, so we're in recess for now. We'll begin tomorrow. As soon as all of you here tomorrow, 8:30, we'll begin the testimony, okay? Oh, where's my other deputy?
Probably didn't have.
Okay, guys, please seated. You're gonna have to give me a second. Let me get my other deputies giving excuses and then we'll escort it back. Okay.
There it is.
All right.
Right for the jury.
Yes, Vito, come on up.
Judge, I have somebody with a bond violation. Mr. Palacios that tested negative when you sent him yesterday.
Okay, so just admonish him not to miss again.
Okay, I will. Miss Emma Lynch, the one that we had multiple conversations about, who's going into patient, you need to set a bond for her because she doesn't have a bond and she's still waiting to be sent to a vet. So I'm asking for a PR bond simply because you're gonna stick her back in jail if she screws up anything anyway.
She's going to treatment.
Right, but she has no bond set on one of her cases. They did. Emma Lynch, do you have the cause number?
Judge, you ready?
Yeah.
2527-041.
Hey, Remind me, is she going to treatment with us? Right? Do you have release instructions not to release anywhere but to Hue, right?
Yes.
That's what's in the contract, but I think.
I need my
Yes,
own
but-
order from either defense or state, like a Harris County General Release Instructions.
I don't.
That, I mean, that normally never happen. I mean, we do as a condition of probation, she's going into treatment. I
But
don't,
it's a DWI.
Yeah, it's not a probation, it's.
So we need.
But it is probation. PTI is monitored by probation.
He's not taking a judgment or a probation.
That's correct.
That's the concept, there's nothing like. He's basically just gonna be.
if I give her a PR bond now, they're just gonna let her out to the
No,
street.
just PR bond along with releasing instructions will hold her.
Right, but
With these two.
who's gonna create the?
So.
I do the court record, but I need the actual instructions signed by you that are given to you, like either state or defense.
So in other words, I have to draft a proposed release instruction.
To the.
I'm fine with
But
that.
there's, talk to Ms. Strong here, because there's a form that's already out there, so you don't have to reinvent the wheel. Ariel Strong, she works with the PDO's office, yeah. And we did one today. What was the case that we did one on? It was,
It looks like this, but this isn't a copy to give. This is just what we
right,
have.
that's what it is. So she can give you that form, so all you just do is input the stuff.
Can you attach me with an email to her of what we need so that I can get it done? Because I don't want her waiting for another 2 weeks to get out.
Yeah, hold on.
And then attach, I guess, Blaze.
Yeah,
so we're
I'll
not
attach
just all
Blaze.
communicating amongst ourselves. Because I think she's pretty certain she'd ignore me if I emailed her or called her.
Yeah.
Sorry. Thank you, Judge. And then I guess I'll file it this afternoon. Do you have my correct email on there, Judge? Nathan, it's Texas Trial Attorney. I don't know, people send it to the ether.
Yeah, no, I have your old one. Hold on a second. Hold on. I'm glad you said something because if they still have that one, it's,
Nathan at the Texas Trial Attorney, and no pompous nature there.
I see. Okay. I'm glad you said something because otherwise it would have gone to the email.
Yes, sir.
Whatever.
Okay. Josh, thanks for being patient.
Yes, sir. So I've got Francisco Garcia on docket today.
Okay.
So it's a jail assault accusation. The complainant is,
You had the jail assault?
was that a co-defendant? So I don't know. I've been able to talk to the chief. I've got Francisco Garcia.
Francisco Ochoa.
Oh, okay. So there's two Franciscos then, that's why. So you said Garcia.
Right. Yes, sir.
So
So I was gonna check with chief, haven't been able to get a hold of, they were gonna evaluate, the complainant just picked up a new robbery and burglary case. So they were gonna evaluate without opinion.
is he in jail?
He's not. He was on his other felony case, but that was.
So do we need to do conditions or does he have conditions already?
I believe. So when I was first appointed, he was in custody, I believe. So I believe he's not, he's waived today, Judge. I wonder if,
No, we need him to sign conditions. He's not signed conditions. Hold on, let me see.
I didn't realize, I just,
Yeah, we need him here. He has not signed conditions. Let me see if this is.
we get chief and maybe find out, he may just be dismissing it, which would. That's all, it sounds like a couple of cases, but.
Okay, I think we're good. We're good.
We're good on that.
I saw conditions.
Okay, so we can reset.
Yeah. I think there's no more reset.
Great,
All right, thanks, John. Okay, ready?
Yes, sir.
Where's Blaze?
He went to the bathroom, I believe. He's coming right back.
I can step down until he gets back in.
Counsel, come on up.
Morning, Judge.
Hey.
I'm Jan Balderas, Marco Balderas, Judge.
Balderas, okay.
I tried back to the DA's office. I had to resubmit. I submitted the wrong format the first time and I had to resubmit it. And they got it, so they're looking.
Have you submitted it?
Yes.
Okay.
And so I just need a
confirm?
short reset, I guess.
Yes, we do have it as of yesterday.
Okay, we'll set you off for a week just to make sure that they can say something. And then if there's no answer, I'll waive the appearance, but if there's an answer, yes or no, then your client has to be here because we'll send them to a T-Rex.
Yes, sir, Judge. Thank you.
Okay, thanks.
Yeah.
Case number.
We did that with 5-7.
You ready for it?
Yeah.
255-9186. Mohammed last name. That was
Yes.
the conditions that were done as we stepped out.
I want to verify that he has active liability insurance before we allow him to drive. That he's not allowed to drive without,
Valid license.
right, no license, Texas driver license, no contact with the complaining witness in this case. That's it.
Are you ways of drove anything?
Nope.
Okay.
No.
Is that state order or you want pre-trial supervised?
You, to make sure that he's got insurance. Thanks. Okay. Come on. Hi.
Here for Adrian Hernandez.
Okay.
So, Mr. Hernandez, his appearance is required today. He is not in court. I would just ask for a very short reset. I have been able to get in contact with him. And I understand that he just forgot that he had a court date today. So just a short reset is all that I would ask for.
Forgot he come to court. Okay, so I'll SFB up to Thursday.
Thank you.
Okay, thanks. Hi. No, we're waiting on Blaze. Come on up.
Do you have time for a plea, Your Honor?
Yes, of course.
Miss Helena.
Is he ready? That's okay. Ms. Johnson.
Be ready on our calendar.
Oh, you too. Okay, I just need to make sure that they're ready and then we'll do this. Call your client up. And then Ms. Hudson has a plea as well.
Okay, we're good. We're good. We got
Do you have, there should be another one too, right? No?
just the one.
No, but she has a plea as well.
Oh, yes.
Is that a DWI as
I'm
well?
getting the thumbs right now.
But is that one a DWI as well?
Yes, they're both first.
I'm gonna do them both.
Okay, so maybe this one. Yes.
Hello, what's your name?
Judge, for what it's worth, my client, assuming the court's okay with it, would like to apply for an driver's license after this. And we'll be working on getting those documents together if the court's inclined.
Counsel, you don't have to. Okay. As long as I got this.
I don't know about doing a time served. He just had one dismissed and he's back now, right again with another DWI and it's a point and it's above a 15. I mean, really?
Sure.
We're still going to continue to do the same thing over and over and over? No, I know you're saying no, but here you are yet again. You had one dismissed, a year and a half ago. Now you're back on another one. It's above a 0.15.
If you give him, if you got an occupation, the court could order some level of treatment, Judge.
He has to do treatment as part of it. So what we do is we'd have him T-RASed, but if I accept this, I'm sticking him with the fine. I'm not going to let him go without the fine.
Would you impose a fine on the probation?
Counsel, for
No.
Let me talk.
Talk to him. It's 4,500 as well, too. No, I'm sorry, 6,000. Yeah. Are you ready, Ms. Gaskin?
Yeah.
Ms. Gaskin, come on up. Good morning, ma'am.
Good morning.
You were charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're entering into a very important agreement today where this DWI will go on your record. It's going to be there for the rest of your life. This is serious business because if you ever get pulled over again and you have some kind of funky smell, whether it's alcohol, whether it's dope, anything, it's probably not going to go well for you because they're going to look that you have a prior DWI. And do you understand?
Yes.
So I would never, even if you've had a sip of alcohol, get into a car because you're begging for trouble. We all make mistakes, but when you continue to make mistakes that you endanger other people's lives, the sentences get longer. You know, the costs go skyrocketing. You understand?
Yes, I do.
So there is a $6,000 surcharge that would tack on because this is a 0.15. I'm going to waive it for you today. If you come back with another DWI, get ready because it gets a whole lot worse. Not only that, from now on, it's a minimum of 90 days in jail. You pick up another one. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do?
I understand.
Okay, how do you plead to the offense, man? Guilty or not guilty? I'm going to find you guilty. Sentence you to 3. Is it true or untrue that you had a 0.15 or above?
It's probably true.
Okay. Do the enhancement. Okay, I'll sentence you to 3 days in jail, credit for the 1 day that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license. I'm going to waive your supervisory fee, but be careful. You come back on another one, it's going to cost you an arm and a leg. Do you understand? For $50, an Uber, take you wherever you want to go. $50.
That's what I'm doing now.
Good. Good luck to you.
Yeah, and I do have a question. There is something weird with her license. We're unable to get a status of her license.
Yes, absolutely.
I think state did just a few minutes ago too, and they couldn't do anything.
I don't know. Gaskin is the last name. I don't know. You know, that's something you may just have to call DPS to figure out. You have your license number, correct?
Yes.
This is the number, Deputy Brand, that's the number to the driver's license division of DPS. Call them right when the phone line's open at 7 and you'll get through. Don't try at 7:20, 1 o'clock, you'll never get through because they're so busy. But if you call right at 7 o'clock in the morning, you'll be able to speak to someone and they can tell you what the problem is.
Judge, even our orange, it won't populate, it won't return to anything. I'm not sure.
There's something's wrong. I don't know. I mean, we only get access to be able to put a number in and it'll spit out information as to the status of the license, why it is. I don't know. Maybe it's got to be an incorrect number or something. Maybe
It doesn't populate with a number, which is odd. It's just a symbol, and then it says an error.
Because in the one in that letter, it was saying something about
The website could be down too.
do something.
Oh, yeah, maybe the website's down. I don't know.
Or something.
I would call them. The best thing to do is just call them. Then you can hear it straight from them. You know, that's what I would do.
All right, and I do have one more question here, and I'm sorry. If we find that her license was previously suspended for 90 days, would you be willing to give her credit for that 90-day suspension?
Yes, but you have to give them the dates and everything.
Gotcha. Yes, sir. Thank you, Your Honor.
Miss, you need the form. Okay, ready?
So,
Please?
Yes, sir.
Mario, if you make it, sorry, if I.
you like Mr. Ochoa to come up?
Huh?
Would you like Mr. Ochoa to come up?
Not yet. He's here though, right?
Yes, sir.
So no, I mean, I've watched the video, Your Honor. From what I can see in the video, it appears he's sitting back, I'm being honest with the court.
Just the whole time, there's not participating in the assault. Does he provide some kind of assistance, encouragement? Does he say, hey, go get him? Or
So the video,
is it a party type?
honestly, the video doesn't have any audio, so I don't know if he's encouraging them, but it does appear that he's just sitting back on a bench.
So how would they find probable cause?
Unless they did not do their due diligence and put the finger on the wrong guy. Simply period. It's clear as,
cops will say, hey, look, this guy's a party to it. He was there. And they don't get access to the video to see it. And maybe they just, and when they're doing magistration, they don't go through the video to look.
I
right?
mean,
That
at the
comes
end of the
later
day,
on.
Judge, with all due respect, before you charge somebody with the criminal offense and putting their freedom at stake, they need to make sure that is who they say it
I
is.
agree with you.
There's a number of people that beat the brakes off of somebody in jail, and Mr. Ochoa had absolutely nothing to do with it, period. He's sitting on a bench from a distance.
But I'm not, you'll find no
And
argument.
now there's,
No idea.
and now there's an open warrant for him, which definitely would affect this court's case as well as the felony.
Look, because sometimes they'll give me information on how someone found probable cause, right?
So I mean, in the offense, there's an offense report saying that he was stomping and punching repeatedly the complaining witness. And it's clear as day, he didn't.
They got the names wrong. There was a Francisco Ochoa, there's a Francisco, so there's different Franciscos. Maybe they got it mixed up.
So the cause number is 255-9198. And I have the video queued up if the court would like to see the video.
He's corroborated. I trust Blaze, I trust you guys,
And I'm being transparent on it.
Yeah, that's. Oh, so this is a 2B.
Yeah.
Active warrant.
Yeah, it's a 2B, so he's never even gone before magistrate.
Well, so
I just won't sign the 2B. I mean, God dog it, then we're gonna have that other problem, because it's always gonna show like a warrant.
So if you, what if you can find the PC? Is that what you're doing?
Yeah, I'm gonna find, I mean, I guess I'll sign it and say no PC on.
And generate the PC form separately.
Okay, I'll do that. Blaze, I'm gonna find no PC if that's what it is.
Your Honor, I'm sorry, Your Honor.
It's okay.
Okay. I'll reach out to felony before it's dismissed. I mean, I've looked at it, being candid here, me and Brad have talked about it. And I've reached out to felony and I'll have an in-person conversation.
Do it sooner rather than later, because it's gonna show always warrant status until it, gets dismissed, right? I'll find no probable cause.
It would just be defendant discharge.
Is that right?
Yes, Judge.
Okay, so that way, because I don't want them to get like pulled over and someone says, okay, so it'll show defendant discharged.
It's not dismissed at this time.
Yeah, they have to dismiss it for it to really go away.
When it works with warrant, if someone's to generate, we'd have to take it to grand jury and get it done. I'm not saying we're doing that, I'm just saying that's how the warrant will generate.
So I'll find no PC.
Okay, all right, thank you, Judge. Thanks, Rich.
Thanks.
I'm sorry.
This is from Guy Jones. Basically, Guy Jones,
Seguido, when I approach. How you doing, Judge? You are always working hard. I admire that.
Not really.
My work, okay.
Tell me, what's going on?
I have Julio, Wilfredo Perez Gomez. All the paperwork is filed. They just need to confirm. And they've already emailed Ms. Gomez. I think it's already.
What's the last name?
Uh,
Is it under Gomez or?
Julio Wilfredo Perez.
It's not Perez, so let's try Gomez.
It's 254-3234.
It's only 128 days. Whatever you want, I mean, really, it's not.
Yeah, well, I would just ask like,
I mean, it's
yeah, I would just ask for just more time.
as much time as you want.
Thank you, Judge.
Counsel, do you need me?
Yes, sir. Judge, I'm here on David Prado, who you said from last week
to make the determination on what type of BIP my client will be doing to resolve the case. It'll be an online BIP course, and so just a standard 30-day reset to get it done, Judge. Prado, Prado.
Well, it's 181 days. Those classes are usually 4 hours. So 2 weeks to get the 4-hour class done?
Okay.
Is that enough?
Works for me.
Okay. It's done. If he doesn't have it done, he's got to be here. Okay?
Okay, Judge.
Thanks.
Thank you.
Okay.
You'll see what I'm.
Yeah,
See what my manner is.
Okay, it's not a big deal.
I feel the same way about this case. It's like,
Of course.
let's see. Helen de Alvarado Mejia. De Alvarado.
Okay.
I'll be one that. In lieu of that.
Okay, and what was the other one?
Oh, she failed again.
She felt like 69.02.
I think 16 hours.
16 hours. Oh my goodness.
I mean, that really says something if you continue to fail just an anti-theft class. How does that happen? You know, are you really just?
What she tells me is this.
Huh?
So this is what she told me. I asked her, hey, I haven't had this happen. So supposedly it's in Spanish, right? That's why I sent them here. But supposedly it starts off in Spanish, but then the rest of the questions are in English. So she had to take it into English and was translating. And it's like, oh my God.
I can't imagine. So do they have these type courses in person?
The 22nd?
Yes, there is an online retail theft. It may take a little time. There is an online, let me go check, see if she's eligible.
For the retail theft program or whatever? Yeah.
Let me go check, see if she's eligible.
Okay.
I'm assuming she is.
Some people benefit more by doing stuff in person or kind of live versus just.
I'm assuming if I gave him, yes, probably.
I mean, isn't that a passing score in college? Isn't that a D, a 60? Or am I making that up?
59's an F, right? So 60.
60s are like you pass.
60 to 70, or to 60 to 69 is a D.
It's a D, right? Yeah.
70 to 79, right, is a C.
Yeah.
Did you?
She
Don't know if I'm just quite admonishments, but is it properly reflected?
And the only issue with that community service stuff is they always ask, why are you doing it? And when they say, hey, it's for, in Spanish, it's robbery. And once they hear that, it's like, no, we can't help you. I just came from court 6 with that issue.
So here's what I kind of, so I haven't gotten into, usually our online, or sorry, retail theft program, it's in there, it's done, we're not, you know, everything. They've put, I don't know, I can't just go offer it, I can check it. So thank you for you. Could do.
Tomorrow, but we have the.
But do they have it in Spanish regardless? You know, because really, if it's in English, you're still not going to benefit her regardless. I don't think that community service is going to, having someone do meaning, I mean, because who knows what the hell she's going to do anyway. No one, the idea is that you learn from this.
Okay.
Looking at it, so.
Okay, you want to have her try it again? You want to do it again? She's here.
Does she have any friends that speak English?
That's the thing. It's supposed to be a Spanish class, Judge. I need to call these people and be
Perhaps
like,
she has a friend that can hang out with her to help her out if there's something in English that pops up.
I've never had it happen like twice in a row like this. Usually I pass on the second one.
But ask her if she has any friends that speak English. No, not here.
Yeah.
Over there.
I'll try to do that. You want to roll her, give her more time to do it, or what are you thinking?
I don't want to just roll it for the sake of rolling. Can you ask her?
Ask her?
If she has friends that speak English that would perhaps help her.
Okay. I understand. Okay, let me do that.
Waiting room? Again, Bruce already proposed to.
Yeah, he's here. All right, Mr. Johnson, you ready?
Yes, Your Honor.
Come on in. You know, I need you to understand that in life, right? We're not going to continue to hope and pray that something bad doesn't happen. We sometimes have to take proactive measures to ensure. You just had one dismissed. You've now picked up another one. If I were to plead you to time served, another proverbial slap on the wrist, and now we're going to let you out there, go out there and hope that you don't kill someone or maim someone or you don't pick up another one, you know? No, that's like the definition of insanity, in wishing that something, over and over, just with a different result. No, this is proactive because here we can see what the issue is. We don't want you to come back with another DWI or much more kill someone because, look at the news. Every day someone dies from a DWI and it's just not fair when it's so freaking preventable by one damn button on your phone. How much money have you spent on both DWIs so far where one button and a $40 fee would have gotten you from A to B? You know what I mean?
Sir.
That's now what we have to do to intervene in hopes that you learn from this so it doesn't happen again. So you've worked out an agreement where they're offering you 1 year in jail and this to be probated for 15 months. As part of this, you will do a repeat offender DWI education class, a victim impact panel, a TRAS, which is an evaluation to see what are the conditions you may need if you need other conditions. If they assess them, you must fulfill them. No drugs, no alcohol, no breath test refusal, meaning that if you're pulled over, an officer asks you to submit a breath test, you must do it while you're on this probation. Guardian interlock, 25 hours of community service, and a $100 one-time donation to Mothers Against Drug Driving. You have children.
No, but I have a 13-year-old brother that relies on me.
Okay. If he does a parenting class, then I'll consider the community service way.
Thank you, Judge.
The idea, all we want is that you learn so that you, in 20 years, this has made enough of an impact on you that you think twice. Oh man, shit, that was such a bad experience. I don't want to do that again. It's either jail or it's a crap load of fines and fees. Do you understand?
Yes, sir.
If you ever have a problem while you're on this probation, all you have to do is come back, let us know. We can work through anything. There's nothing too big, nothing too small. But the worst possible thing you can do is drive without a license or insurance, start using, or pick up another DWI. So you understand?
Yes, sir.
The other thing that if you just take off, abscond, that's also an instantaneous warrant. If you violate this probation, that's what we do. We issue a warrant. We have a hearing to determine whether you violated it. If you do, you're looking at an entire year. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, this is going on your record now. It'll be there for the rest of your life. Do you understand?
Yes, sir.
From now on, you're facing a minimum of 90 days in jail. You ever pick up another one. Do you understand?
Yes, sir.
And I'm going to tell you now, you get pulled over. An officer, the first thing they do is they look at your record. They're going to see DWI, DWI. What do you think they're going to do? Do you think they're going to harass and harangue the hell out of you? Every time you get pulled over. And if they smell anything funky, it's probably not going to go well. You understand?
Yes, sir.
Is it true or untrue that you had a 0.15 or above in this case?
True.
True to the enhancement. All right. How do you plead to the office? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I'm going to send you to it. I'm not going to suspend your license now, but I'm going to tell you, can you look up his license please to see if it's suspended?
Judge, I'm sorry, I missed his name.
Arredondo.
Yeah. It is not eligible, Your Honor.
Okay. So you will be signing a non-driving affidavit. If you drove here today, you are not allowed to drive home. Your license is suspended as of this time. If we catch you driving without a license, I'm gonna lose it. Do you understand?
Yes, sir.
Do not drive. You are required to have a guardian interlock, and every officer, because we send notice to DPS, every officer in the state knows if they pull you over and you don't have an interlock, you're going to jail. Do you understand?
Yes, sir.
That's for the traffic, right? That's why it's ineligible, right? So traffic.
I don't believe so. I took care of those yesterday. So.
Judge, I believe his license may be showing ineligible due to a traffic ticket. If we can get that sorted, can we come back and?
I'm okay with an occupational as long as he's in compliance, okay? The other thing is this, is he is now taking a subsequent DWI education class. DPS is probably going to suspend your license regardless because of a subsequent DWI education class, if you've already taken it. Did he do a diversion and it got dismissed? As part of the diversion, you have to do a DWI education class. Subsequent ones get your license suspended. So I would check with DPS first. Don't just start driving, when you take care of that ticket, because they're going to probably suspend your license again. And this time it may be like a 2-year suspension. I'm okay with an occupational as long as he's in compliance.
Yes, sir.
And he has an interlock first. Okay. All right. So we're going to have you meet with Shatori for all your conditions, and then good luck to you, sir.
Thanks, sir.
Thank you. Waive the supervisor fee. I mean, not your fee, the 6,000.
Okay.
So it's, yeah, but it should be 6,000 because it's a 0.5. It's not 4,500. It's a 6,000.
Yes, sir.
Yeah. Mr. Broussard.
Hey, Judge, good afternoon.
Hey, have a good afternoon.
Judge, my apologies. I thought that when I was in there last week, that took care of it, so I was not prepared to come to court today.
Vic, who's he here on?
Jail case, page 41, 42. He filed a motion to withdraw.
Oh, we put it on for today for when? Why did we put it on for today? I don't remember.
Maybe for him to withdraw?
Well, Judge, you wanted me to have it heard in the felony court first, which they
That's-
did. And the order's been signed up there, so I didn't know what effect that would have on your court.
Yeah, can you appoint him someone? Oh, because, right, I remember now, because I didn't want him to withdraw and then he's in jail and it looks like he's in jail without a lawyer. That's why we did that. Well, no, I didn't want to sign it then because then he was not on the docket that day. He was upstairs in felony court, so we didn't have him here. So we would have effectively reset him, withdraw him, and then he looks like he doesn't have a lawyer at all. I didn't want to do that. So I'll grant your motion now, Mr. Broussard, and then we'll appoint him a lawyer.
Okay, thank you, Judge.
Okay, man.
All right, take care.
You too. Okay, you ready?
Yeah, reapproaching on Ms. De Alvarado. So, she's got somebody that could help her on the English one, but I told her, hey, talk to them, see why you're not getting the Spanish one, first of all. And then in the alternative, she's got a cousin that could help her.
Okay, so let's set it off a week for her to do it again.
All right, let's do that. Okay, thank you, Judge. Appreciate it. Is appearance required?
If she fails it again. Tell her we're gonna keep doing it till she passes.
Okay.
I want her to learn.
Okay.
How much time?
A week.
Talk about.
Okay.
Is, Mr. O'Neill, yeah. So I was able to talk to his father finally, but he was at the hospital, checking on his wife, and he wanted to talk to me later. So I don't have an answer yet about, the home and everything, whether or not.
Roll it to later this week and I can waive his appearance.
Sure.
Does he have a cell phone or no?
No, he doesn't have his cell phone's at the house and his ID and everything's at the house because they arrested him basically in his underwear. And so, but
She said that she's willing to put it outside the house, right? You want to schedule a time that he can come get it? Perhaps? You guys just coordinate a time?
Sure, do that.
Just tell him not to knock on the door, try to have contact with her, just literally pick the stuff up and go.
Okay. Now
They've got in garbage bags ready for him, so just coordinate a time.
And so right now he can't he didn't have anywhere to stay. He stayed in Star Hope, and every day he has to take everything with him, when you leave there.
I know.
But he could go through, I guess, and pick out what he needs and then, go from there. I did talk with his sister and family's trying to help him.
Stay with his sister. Here?
Sorry?
Where's sister here?
She's, it was the North Harris County.
But he stay with her?
No,
She won't let him stay?
yeah, she doesn't want to have him stay with her. Muskee Road, way out there, 290. It's kind of far.
You don't want him to stay?
No. But she's not over to the house and all that, so, but the dad was, but he just couldn't talk to me. He was, I didn't have a number for him, so I kind of knew where the hospital was, but his description, so I tracked down the hospital and.
Alienated, you have nowhere else to go, but,
Yeah.
I mean, my fear is that if he goes back to the house, more bad stuff's gonna happen, and that's what we're trying to prevent, you know? I mean. Harold, I'll do whatever you want to do if you want to
Sure,
set a week, a day, or later this week, whatever.
can we say like next Monday? That'll be good.
Whatever.
And then between now and then, I guess if,
Right, I mean, what I would say is if you could reach out to her, ask her what's a good day and time for him to come pick the stuff up, so she knows that she's not there, right? Maybe at the time when someone else is there, so that someone sees him getting it. So don't leave it just out by the front so someone else can take it, maybe leave it in the backyard or, just be conscientious because we don't want someone else to take it, and then. Or maybe she can be there and that way she leaves it out right before he comes. That way someone doesn't take it. I don't know. Harold, what do you think?
yeah, we'll say Tuesday. I don't know, maybe if she could do, I guess we kind of need to know what day. Could you reach out to her now? You think she's available or
Yeah, I can reach out to her.
see what Wednesday or Thursday is a good day?
Yeah, and do you know a time that would work?
You guys decide that off so that I don't want to get involved and I don't want to live stream everything that,
And then Judge, we also had Mr. Savage in the holdover. And he has an MAJ, in here on probation case. But while he was in drug treatment for the probation, he picked up another case. And then I think after he got out, the story I'm getting is after he got out of the probation.
Yes, so he
We
got
come back.
placed on probation back in 2022 for an assault. He completed a part of that probation, he was to go to SAT. And while he was there, he picked up a felony charge, they ended up putting him on probation. And then while he started going to aftercare, he tested positive for amphetamines, meth, and benzos, and then he just absconded from both our probation and the fellow's probation.
Okay.
And so that's why it's been a couple of years, right?
Yeah, I guess it's time to let's be done with it, right?
Well, he was asking me, I don't want to speak for him. I can't remember if he told me he's clean now, but he was interested in trying to restart everything.
I mean, really.
Too far out.
You get on the assault with us. While you're on probation for assault, you pick up a felony. While you're on both probations, you start testing and then get abscond.
I think the felony was getting drugs while you're in the program. So, I think it's really a drug problem. It's not a.
Yeah, unfortunately, we don't have as many tools as felony courts has to address, and I don't know what they'll do up there. Perhaps they'll put them back on there and keep him in treatment. I don't know, but.
Is it possible to? Wow.
This thing's been going on for 2 years,
How much did we complete of it? I didn't ask for that part of it.
My feeling is probably nothing because he's been in treatment for
Like just
They're in treatment or absconded.
Bid, and he's behind his feet in the aftercare. That's the participant.
So this is the kind of thing where we could terminate unsuccessfully, let him deal with the felony.
I mean, I'm willing to give him back time, but true to the, I wouldn't want to unsat term him because that would in effect, he wouldn't end up with the affirmative finding thing, so I'm willing to do the back time, but you'd have to,
We're just not sure if that will affect his felony one. I guess it wouldn't, because it predates the felony. So it wouldn't, yeah. Okay.
If you want a couple days to do research and think about it, I'm okay with it too. You want to do that?
You do that?
Yeah.
Sure, we can.
So set it for maybe next week, take a look, but Harold, really, are we gonna put him back on when he hasn't done anything? He absconded, had dope while he's in treatment, and then he's still doing while he's out.
Just sound like we didn't commit to it initially. We weren't really struggling with it, with the addiction, maybe, and not committed.
I get it, but at some point we have to say when, and I think that's not. But I'm willing to give you time to look to see, and maybe get in contact with a felony lawyer to see, whether it would have any kind of impact or not. So you pick the day, whatever you want. All right. Okay.
Thank you. Have a use.
Okay. Mr. Tolentino?
Yeah, he's considered discovery.
There's a Tolentino judge, it's a deferred. No, Judge, he's a US citizen.
Morning, Mr. Tolentino.
Morning.
So you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully. If you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this. And if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change. No drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're on the probation as well. I'll make you a deal. If you do well, you get everything done quick, I'll take you off in half the time. Meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand?
So.
All right, bud. Good luck to you, sir.
Thank you, Judge.
Thanks, John. Okay. Blessing. Yeah, I think we have a plea.
I think so too.
Yeah.
Restriction. But there's, we're not here today.
You can waive it.
We don't.
You mean the signature you want, right?
Yes.
Yeah, of course.
Schedule is over.
Yeah.
Page 15, Hodges, but she.
She hasn't coached yet.
How is this case 190 and it's still waived?
It's what?
It's 190 days old and it's waived. How's that?
I strictly no all the time.
Okay, so
This is 180.
at 1 week SFBF.
Well, she's here, but I'm saying, I know it's set, she was expecting the plea papers and to plea. So I know she was up there. Was that who fled, Hodges?
No,
No?
no.
The plea paper?
Oh, she
Yeah.
pled.
Plea is in there, but we haven't taken any signatures or anything. Oh, okay, let me email her.
Hodges? You're here? Okay. Yeah, you want to reach out to her? She was here earlier. Are you ready?
I did get a new appointment today, and it's Mr. Dolphus. And I just wanted to see if I can just get a little time to, download the evidence.
No.
Oh, shoot.
Do it now.
All right, I'm ready. Set it for charge.
Is he in jail?
He is, Judge.
Do you mind, what's his name?
Dolphus?
No, the other guy, your plea.
Oh, Jamel, Chimeo. But we don't have the plea paperwork ready yet.
Oh, you don't, oh, okay, sorry.
Just wanted to put you on Mr. Dolphus. Sounds good. Thank you, Judge. I'll be right back on Mr. Jamel whenever that's ready.
Sorry, boss, I thought it was ready. Good morning, Miss Morgan.
Good morning, Judge.
You need to put your last name on there so I know it's you. If I don't know.
Sounds good, Judge.
I don't let him in, okay? Please.
Understood. Yeah, my Zoom in is not logged on. This is a new computer, so barely adjusting.
You got De Mejia.
Yes, Your Honor.
What do you want to do?
Yes, Your Honor. So I was emailing the state over the weekend. They did release some videos on one of the cases on the 17th. I haven't had a chance to review them. My understanding is Mr. Mejia wants to take some sort of agreement.
Okay, so we'll just give you more time.
Yes, Your Honor. I was gonna ask if it can be rolled to tomorrow, and I mean I already have access to the videos. I was reviewing some of them right now.
You really want to do that?
Negotiating with the
Tomorrow, or do you
state.
want more time?
No, I can roll it to tomorrow, Judge.
Okay,
What do we expect them tomorrow?
videos.
Videos?
She gonna watch.
Don't watch them?
All right, so you sure for tomorrow then?
Yes, Your Honor.
Okay, you got it.
All right. Thank you, Judge.
Okay, see you tomorrow.
Maybe excused?
Yes, ma'am.
Yeah.
You got it? Wonderful. Can I?
Give us like 2 minutes to get it ready and then we'll go ready.
Slow poke.
Good
morning, Mr. Chimeo.
Good
morning.
Good morning.
Charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You need to understand that this charge from now on will go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days for any new cases, at least with DWIs that you pick up. You ever get pulled over again, officers will see this DWI and they roll up to your window and they smell alcohol, or if they smell dope, it's probably not going to go well for you. So I would never get into a car and drive if you've even had a sip of alcohol. Do you understand?
Yes.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, you give up the right to appeal. Meaning, once you plead guilty, this goes on your record and it will be there for the rest of your life. Is this what you want to do?
That's it.
Yes.
Is it true or untrue that you had a 0.15 or above breath test?
True.
Find that it's true. I'm now going to sentence you to 27 days, give you credit for the 9 days that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license, and good luck to you, sir. Thanks.
Judge, I was appointed to this case about 8 days ago, Judge, and I don't believe the sentence status has changed since then. Can we ask the court to waive the DPS fee? Thank you, Judge.
Okay.
Bennett,
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now 21 cases. Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just in 25, PCS, unauthorized use, and now you have an evading arrest.
Those guys.
Stop. I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me?
Yes,
You're
Your
now
Honor.
charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? He's not doing anything. Just presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. Be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. It's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat. Sir, your case is being dismissed. You're free to go. Hey, Josh.
Hello, Judge. Can you hear me? Yes, I believe Ms. Park appeared, is my understanding.
Give me a second. Hold on. Let me just stop a second. Okay, what?
Yes, it's my understanding Ms. Park earlier, but she's there now, Judge. And so Victoria asked me to
Page 36, Park, she's set for trial and showed up about 1 o'clock.
Come up, ma'am. Today is your trial setting and you show up at 1 o'clock. Really?
I didn't start late though, but I got lost.
I'm sending you for a drug and alcohol test right now, and then I'm rolling your case until tomorrow. You must be back here tomorrow. You understand me?
Yes.
Please take a seat.
Yes, Judge, and I will be there tomorrow morning.
Okay, thanks, Josh.
Thank you.
And tomorrow, 9 o'clock, not 2, not 1, not 10:30, 9 o'clock. Last name is
Hodges.
Yes. All right. So, good afternoon, Mr. Hodges. So your charge is failure to stop and give information. You have worked out an agreement where they're offering you a 6-month deferred. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record. But you cannot tell people it was dismissed. It does not get dismissed. You merely take a probation, complete it successfully. You don't end up with a conviction. Do you understand? Sir. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charge read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, there's no turning back. Do you understand? Yes, sir. Is this what you want to do? Yes, sir. Was there no restitution that was due in this? Hey, Blaze.
Yes, sir.
On Mr. Hodges, was there any restitution that was due? It's an FSGI.
Hold on, hang on.
The agreement that I see so far is a 6-month deferred. No drugs, no alcohol, random testing, and 20 hours of community service.
There's no monetary damages, Your Honor.
No? Okay. Do you understand this?
Yes, sir.
If you get this done quick and there's no problems and you're nice to everybody, especially the probation officers, I'll take you off and half the time as a reward.
Yes, sir.
But if you pick up a new case, you take off, if you do something to violate this agreement, I will issue a warrant for your arrest and you're looking at 180 days in jail. So you understand?
Yes, sir.
All right. How do you plead to the offense? Guilty or not guilty? No. It's either guilty or it's not guilty.
Guilty.
All right. I'm not going to find you guilty now. I will withhold that for 6 months, give you the opportunity to complete this. And if you complete it, that's when you don't end up with conviction. If you violate this, though, we put you in jail, bring you out, we'll have a hearing. And if you violate it, like I said, you're looking at 180 days. Do you understand?
Yes, sir.
Okay, good luck to you.
Thank you.